Hello, everybody.
Okay, let's go back then. I think that takes us to number 7. This is Robert Myers v. Nicholas Carer. I know you all have been waiting as well, Ms. Winkles, Mr. Kiernan, and I did get some additional bench material, so let me just grab those. So I have it in front of me.
Your Honor, if I
Yes.
may, I'm assuming that Mr. Kiernan is going to ask for a trial. However, given the information you have and under RCW 5918.375 subsection 2, and also under RCW 5918.410 and the Housing Authority of Grant County versus New Bigging, we'd ask that Mr. Carer put money into the court registry. During any unlawful detainer action, even for the non-payment of rent, he is to place any funds that are due for rent into the court registry. You'll see that he has agreed in September that he paid $1,000. You'll see that my client supplied, even though they said it was oral, you'll see the document state that they signed stating that the rent was going to go up to $2,650. They haven't paid. They haven't paid since September. So they owe $1,650 in September, $2,650 in October, $2,650 in November, because we're now in November 22nd. I'd ask, Your Honor, that they pay $6,950 into the court registry. If they can't do that, then the order for writ should be signed without a trial. And that again is under Housing Authority of Grant County v. New Bigging, and also RCW 5918.380, 5918.410.
Your Honor, this is not for non-payment of rent. This is for a behavioral issue.
It doesn't matter. It's actually for, there is a general.
Hold on. Let me just hear from Mr. Kiernan and then Ms. Winkles. I'll come back to you.
Okay.
Yeah, I mean, if we want to do some briefing on this matter, I was not certainly on notice of this, Your Honor. This has not been what our practice has been as far as what we have done in the past. I'm not as familiar with that. I know that if a writ is issued and under 410.3, and then we go to trial, then they need to post a bond. But I'm not aware that they need to post a bond just for the sake of hearing their rights. And quite frankly, I'm a little bit, I don't know what this reading of the statute could possibly be correct, because they're basically saying that my clients need to pay $6,000 in order to exercise their rights to a jury trial, which the state of Washington is pretty clear that they have a right to a jury trial. So, Your Honor, if this is going to be an issue, I would ask to just brief it and have some additional time, because I'm not saying that Ms. Winkles might not be correct, but that's certainly not been what the practice has been on this docket. Quite frankly, I don't think my client should have to pay $6,000, which the defendant has failed to accept just to exercise their legal rights, Your Honor.
And Your Honor, if I may, there is a general requirement of paying rent when you have a lease. And there is a general requirement to pay rent into the court registry, even if the action is not exclusively tied to the non-payment of rent, is a general requirement in all unlawful detainer proceedings. And that's the Housing Authority of Grant County. The fact is that doesn't make any sense. They're not trying to exercise their right to a jury trial. They're trying to stay in possession of the house. If they're in possession of the house, which they have been, then they need to pay rent. Otherwise, they need to remove themselves from the house. So this is the issue here, is that it makes no sense to set a jury trial for an action that isn't about rent, and then they don't pay the rent. So we're not asking for a judgment. We're not asking for anything. We're asking for them to pay what they would normally pay in rent into the court registry. This matter was set back in September. I believe, oh, sorry, my apologies, back at the beginning of October. So we can ignore September. September is when the action happened. Just looking at when we've been in this legal sphere, it's October, November. And so if the action's not about rent, why do they then get the added benefits? They're still there in possession of the house. Why do they get the added benefit of not paying rent when the action's not for rent? It doesn't make any sense, because then do they get 2 months for free because we started a court case? That doesn't make any sense. It's not going to my client, it's going into the court registry. But they have it, there is a general requirement. RCW 5918.410 outlines that if the proceeding for an unlawful detainer after neglect or failure to perform any condition or covenant in the lease that you can, as the court, assess rent due. And that supports the notion that rent payments in the court registry can be provided in the broader context of any unlawful detainer action. The fact is that we don't do those in this court normally because we're here for 2 weeks, maybe a month.
Yeah. So let me ask this though, because none of this was, I wasn't prepped for any of this either, because all of the pleadings were as it pertains to the show cause motion. So let me back up just a little bit. Is there a request for a jury trial? Is that what the tenant is requesting?
Yes, we believe that there's a material issue of fact here. My client, I believe this is going to come down to a credibility issue. My client says that this issue never happened. Their clients, I mean, they're saying that it did happen, Your Honor. Ultimately, we're going to have to do a credibility assessment. The case law is pretty clear that should not happen at a show cause hearing, which is an expedited procedure. And again, I mean, it makes sense why they don't collect rent during it, because there's the waiver argument, Your Honor. So they have waived the right to collect rent because they have considered the tenancy over once that they have so technically rent is not due once the notice expires. They have holdover damages, Your Honor, which is different.
That still means that September's due. So that argument would negate that. But more importantly, there is a restraining order in place right now, DVP, or sorry, a restraining order. The fact is once that's adjudicated, there's no need for a jury trial because it's going to be adjudicated by a court of authority. So I'm not sure why they would get that. Number two, the credibility issue. This is also from the person that said that it was an oral increase to increase rent, and we just put that in. But more importantly, there is nothing that negates what happened. You'll notice what my client stated. Mr. Carer's declaration is the only one at issue in this case, or the only one that's on the record. The rest is all hearsay, and we did object on the record. If you notice in his declaration, he doesn't state that he didn't say what my client stated. He doesn't state that my client cannot enjoy his residence. That's what the waste is for. The waste is a 3-day waste for nuisance.
Mm-hmm.
The fact is my client can't leave his house and had to get a temporary protection order.
Okay. So here's what I'm gonna do, because I think a lot of issues are showing up on the show cause. I don't have motions in front of me for either a stay of rent pending the case. I don't have a motion to require payment of rent. None of that is in front of me. I do want briefing on that. So a couple things I'm gonna do today. There is on the underlying reason, so the 3-day nuisance notice, the reason that this specific cause number was filed, there does appear to be a material issue of disputed fact. We will set it for trial. Let me see if
Your Honor,
yes.
we probably won't need to do that. What I'm going to do is I'm going to file for a non-payment of rent, and I'll dismiss this case because then they will owe the $6,950. So let's go ahead and set a jury trial. But I'm just letting the court and everybody know what I'm planning on doing.
Okay.
May I put something?
If your attorney wants you to speak, it might do you more harm than good. It's up to your attorney.
I think I will allow you to speak, but I might cut you off.
Okay, go ahead.
Your Honor, I just want it understood that our not giving the property over at this point wasn't a choice by us. His restraining order has made it nearly impossible for us to move out in a timely fashion. We have no intention of keeping the residence or disputing that in any way. It's actually his motion with the restraining order that has prevented our timely moving out.
Okay, well,
okay, yeah, I don't think we need to have too much of our conversation. Yeah, and it sounds like my clients are going to be out by the 1st, quite frankly, Your Honor.
Right, here's the deal. If a court put a restraining order into place, then that's not his fault. That means that there's.
I would just like to note it's a temporary order, Your Honor. It has not been adjudicated.
Damage control.
It was completely granted.
But let's not talk, Mr. Carrer. I think we can just.
Yeah. Okay.
Let's.
Yeah. Okay. Well, so Ms. Winkles, are you making an oral motion to dismiss, or do you want me to get you at least for now set on trial assignment calendar for a jury trial, and then you file what you want to file?
Let's do the briefing first on, let's set it, can we set it for 2 weeks of the briefing, and then in the time I might dismiss and just file for the rent.
That's my.
Do you want to just have this on the trial setting docket for maybe December 3rd?
No, I don't think we need it. Just the set over for 2 weeks and for the briefing.
Okay. Quite frankly, I think this might be moot by then.
Okay. So let's do this. Let's we do have timelines that jump in when a jury trial is requested. So what I'm going to do right now is just continue the jury trial request and the briefing on rent pending a 3-day nuisance complaint to December 6th at 9 a.m. If the parties want to file briefing on that issue, feel free, or it sounds like there might be some other way this resolves before then. Does that work for the parties?
That works, Your Honor.
Yes, it does, Your Honor.
Okay, so Mr. Kara, thank you for being here and being patient with us for this lengthy docket. No action taken today. We'll be back on December 6th unless you hear from your attorney between now and then.
Thank you, Your Honor, for your time.
Okay, thank you. And then any other ones, Mr. Kiernan?
Oh, I guess maybe the Carer matter with Ms. Winkles. I think we're trying to strike that. I think they're going to pursue another action, but I think my client is going to be out at the end of the day.
Let's see, I know Ms. Winkles also has a Wahkiakum docket, but Ms. Winkles, are you with us? Okay,
Let's hold off on that.
Oh yeah, I'll call that one back. She did send a message about a separate docket.
I am, Your Honor. Can you hear
Oh,
me?
there you are. Did you want to? Oh, Ms. Winkles, did you want to handle your matter or wait?
My apologies. I'm in two dockets at the same time. If we could handle my matter now, that would be wonderful.
Okay, this is number 7 on the docket, 242-010-1108, Myers v. Carer. How are the parties asking to proceed?
Your Honor, I'm asking to go ahead and proceed with the unlawful detainer and ask for a writ. There was a domestic violence, there was an anti-harassment order already entered, and even though it was entered by default, there were findings made. Therefore, I believe it fulfills the statute, and so I'd ask for the writ to be entered today.
Mr. Kiernan, it's a little bit different than how you thought you might be proceeding today. So
certainly different. Well, I believe last week we said that there was a material issue of fact here, at least as to if there was, a situation. So I'd ask that you set the matter to trial then, Your Honor.
And because there's no question of fact, because findings have already been made by a judicial officer, I'd ask that the writ be entered.
I just don't think a default judgment would be, a correct way, especially when we already had findings in the record from my client. I just don't think that would be appropriate, Your Honor.
And so just so I am clear, the idea is that because the protection order was entered and there were findings made in that precludes any sort of disputed factual issue in this case. Is that what I'm understanding the argument to be?
Yes, because there were findings as to harassment. He was given a notice as to harassment, and that was the basis for the 60-day notice that my client gave was harassment.
So my only concern with that is that, as both of you know, in civil protection order cases, the rules of evidence are relaxed. So oftentimes things that would be otherwise inadmissible in a normal civil case can be admitted and decided upon by a judge. So I do want to be careful about what potentially, I guess I think it's a little bit of apples to oranges. So I guess Ms. Winkles, you can respond to that.
Yes, Your Honor. When there are findings as to harassment, essentially, even though other evidence comes in, the civil protection order essentially excludes this person anyway from being there for a year on that property. Furthermore, under the Unlawful Detainer Act, there is a caveat that if the owner is unable to enjoy his property, and if the tenant is harassing them, that you can give a 60-day notice and the person needs to move. That 60 days has come and gone. He has not moved. He was provided notice. There is harassment. There are findings as to harassment. Harassment is a low threshold anyway. It's not domestic violence. It's not anything of that nature. So in this case, Your Honor, I believe it is justified. He was given proper notice. There's nothing like he's moving out the next day. So we'd ask for the writ to be entered.
Mr. Kiernan.
Yeah, I mean, I'd first off just like to respond. I didn't even know that there was a protection order that was issued until just 5 seconds ago. So I just like notice and be able to address that with my client if we're going to be through this. But Quite frankly, I think this is a separate matter. This involves, the RLTA, which has very different standards than a protection. I think we've created a material issue of fact. My client is vigorously, saying that this didn't happen. I think we might be in a slightly different situation, Your Honor, if this wasn't just a default judgment. But my client essentially never really had a chance to vindicate the facts of this matter. And when he was represented, had an attorney, we did strongly dispute these matters. And I think we've created a factual problem, Your Honor.
Yeah, I mean, I know when we were here last, essentially, and I'll be honest, I don't see and I'm going to look through any unscanned documents. I didn't see that the protection order was entered into evidence here. Yeah, I don't have anything new. So since we were last here, so let me back up to where I know we were on the 22nd. At that time, we did discuss material issues of fact. My ruling on the 22nd was I was requesting briefing on the issues presented. I found there was a material issue of fact on the underlying issues and that it should be set for trial. In lieu of getting you all set at trial, the parties discussed continuing it 2 weeks for additional briefing. I have not received additional briefing. So the options for the parties, again, noting that the civil protection order is not in evidence here. So I can't simply, because it's the same court, I can't pull in a protection order that was done on a different docket into evidence in this case. It is actually not in front of me. So
he did cite the civil protection order in his last reply pleading. He actually cited that he was going to that docket, that obviously the outcome of that was not entered, but the docket is.
So it's not right. So it's not in evidence here. So I can't simply just go look at another docket to take those findings and put it into here. So what I can do are two options. I previously 2 weeks ago found that there were disputed issues of fact. Nothing new has been presented to me, but in terms of admissible evidence. So I can allow you all additional time to submit that briefing and we can hold a further hearing, or I can put you on trial assignment and you can set this for trial.
Your Honor, I'd ask to strike. I tried to actually strike this a week ago, but I guess because it was a show cause, the court wanted me to come anyway. And then obviously the DVP or the anti-harassment was granted. So then I obviously thought, okay. So I think if we can just strike this, my intention is still to file under the pay or vacate. And I think that's what we're going to do.
Okay. Mr. Kiernan, since they are the moving party and the request now is to strike, I assume no objection.
No objection, Your Honor.
Okay, we'll go ahead and just strike number 7. Thank you both.
Thank you.
Okay.
I love you guys all so much. You've been amazing. Be safe, be well, sleep sweet, and much love.